Marriage, impotence, and other private things like intimacy are rarely discussed in public. However, erectile dysfunction came under closer study in Europe in the 14th century. Prior to the French Revolution, a woman may publicly accuse her husband of impotence in order to have the marriage dissolved. Impotence as a basis for divorce wasn't unique to France. Similar accusations were made in medieval Spain and England as well. The methods by which men had to prove their virility reached increasingly invasive and public levels during the early modern period, with intricate medical exams, virginity tests, and even trial by Congress, a public display of one's intimate ability. The public carefully and even religiously followed these trials during their brief existence, despite the fact that they were a completely inappropriate manner of judging if a man was capable of carrying out his marital obligation. Without a doubt, pre-revolutionary impotence trials made public what we now see as private problems. The church had a right to be in your bedroom. Catholics and Protestants among others claimed that marriage was the only morally acceptable way for people to satisfy their sensual impulses in the 16th century. Impotence was viewed in this context as a dishonest crime committed against one's spouse. The Catholic Church did not formally recognize marriage as a sacrament until the Council of Trent, despite the fact that clergymen and theologians had been engaged in matrimony throughout late antiquity and the Middle Ages. Christians who participated in marriage in its sacramental form recognized that it was a contract with specific terms. Marriage was indissoluble, between two baptized Christians, monogamous, and for the sake of procreation. Marriage was viewed by Protestants as a vital institution, much like it was by Catholics. All religious leaders, whether Catholic or Protestant, concurred that impotence was a legitimate reason to end a marriage and that it was a matter of church business. Divorce was rare, so impotence was a woman's best means to quit. In the Middle Ages and the early modern era, the Catholic Church did not provide many alternatives to marriage. The primary objectives of a marriage partnership were to facilitate reproduction and serve as the only legal outlet for intimate impulses. An annulment was therefore permitted if a man was unable to fulfill his obligations in those areas. However, the details of such an annulment were far from straightforward. Before an annulment was granted if a woman claimed to be impotent, a 3-year window was established in case the condition somehow improved. Furthermore, not all annulments permitted the parties involved to get remarried. Depending on what was understood about the problem's genesis, this was necessary. Although they thought that remarriage was necessary, Protestant reformers nevertheless saw impotence as a legitimate cause for divorce. For Protestants, impotence could only be brought up in court once enough time had passed for procreation to occur, which might be anywhere between 1 and 3 years, and divorce was only granted following a series of oaths or medical tests. In 16th century France, impotence was a widespread cultural problem. One could surmise the existence of an environmental causation based on the number of impotence cases in France by the 16th century. Of course, being one of the few options to end a marriage, it was a process that appealed to a woman who was trapped in an unhappy union. Women from upper and middle-class backgrounds were more likely to file lawsuits because they could afford to do so. Impotence trials have seen a rise in both interest and number due to a number of variables. Treatises and literature regarding marriage and the law became more and more common as such instances increased in frequency. Up to 10,000 trials were conducted during the 17th century. Contemporaries blamed women's increased audacity and overt sexuality as well as general moral decay for the increase in prosecutions. An innocent wife had to vouch for herself. Even though these so-called impotence trials were initiated by women, the wives involved still had to establish that they weren't to blame for their partner's infidelity. She then had to prove she was still a virgin for the trial to continue, because the wife's best chance of escaping a miserable marriage was to assert that the relationship was never consummated. Drinking a diuretic was one way to demonstrate this. If she urinated right away, her hymen had been compromised because the urinary and reproductive systems were thought to be identical. A woman who is not penetrated would purportedly not be impacted. She was frequently examined physically as well. Her husband had to be put through a physical examination in order to prove his deficiency in intimate activity, which was a different way to demonstrate her innocence. For instance, a suspect husband's examination in 1370 revealed that he had a member, like an empty intestine of mottled skin, which neither expanded nor grew. The man's marriage was declared null and void a few days following this investigation. Ironically, a virginity test could deflower a woman. Naturally intrusive, the physical test a lady had to pass to demonstrate her virginity. In the presence of midwives and doctors, she was bathed and placed on a bed. To examine the woman's vaginal canal, a mirror of the womb was then implanted. This method of determining virginity was utilized despite the fact that breaking a woman's hymen was feasible, and probably likely, in such an invasive process. If a woman insisted she wasn't a virgin, she might contend that her husband had broken her hymen by touching her inappropriately or by trying failed action on her. Men had to perform in front of the public. The virility of a man was tested by several Spanish doctors in the 14th century by immersing his manly thing in cold and then hot water and watching for blood flow and dilatation. A male surgeon would subsequently try to induce erection in the patient if the results of this test were unclear. Matrones, or female private specialists, were consulted in Naples. This woman would go with a couple, calm them down, give them aphrodisiacs, and watch for the outcome. After that, she would update the court.
There is no sign of corruption or violation.
Men were supposed to stand up straight and have spontaneous affairs with their wives in front of the court during a trial by Congress, as was customarily conducted in France. Church leaders and medical professionals did appear to acknowledge that the inability to perform in front of an audience may be caused by the discomfort of the public setting, but generally speaking, these trials' findings were strict. An impotence trial could lead to one of three scenarios. There were three possibilities that could occur if a man and woman in an impotence trial adhered to their 3-year trial period, put up with the physical examinations, and submitted all the information necessary to the court. If erectile dysfunction was not established, the couples were condemned to live as man and wife. If the impotence was established, the marriage might be dissolved with the exception that either party could later remarry. Finally, the pair was occasionally required to suffer another 3-year trial period in case the situation improved. Men's defenses included sickness and evil spells. Men have cited being under a magic spell as one defense for their supposed impotence. The association between magic and impotence was widespread during the Middle Ages, and it grew stronger as the public's awareness of witches grew in the 16th and 17th centuries. In 1603, Jacques de Sales claimed that his wife's magic spell was to blame for his impotence. Both parties were permitted to be remarried after the annulment was issued. After the 17th century, the theory of frigidity through evil spell became discredited. Men would frequently assert that impotence was transient and was brought on by indigestion, a cold, a fractured rib, or another condition of a such nature. Additionally, they would assert that their frigid wives were turning down their advances. A desperate man would assert that his wife had once been pregnant as unmistakable evidence of his prowess. Some cases of impotence lasted for years. An impotence study typically lasted several months, however they could go on for much longer. Sometimes, a party might leave because they didn't want to submit to the physical examination, usually the male. The trial of Diego Belasca and Jeromina Martinez de Texada in Spain in the 1680s lasted 15 months. The Marquis de Gesvres, Marie Mascaroni, and Joachim Bernard Poyer's 1712 French case lasted until his wife withdrew the charge in 1717. Attorneys dispute women's perceived advantage. Lawyers for the men accused of impotence were some of the trial by Congress's most vocal opponents. All of the advantages of the procedure, according to Vincent Tagereau, belonged to the wife. In terms of performance, the weight of proof obviously fell on the guy, but women were free to manipulate, lie, pretend to be virgins, and abuse any resentment they may have had for their spouses. It was especially alarming that virginity might be recreated. A lady might inject herself with animal blood or contract her vagina using an astringent. Tagereau claimed that such wicked and immodest procedures whose custom it is to sell whores as maids, rendered women unreliable. Overall, a man's reputation was at more risk due to impotence than a woman's. In the wake of some of these trials, according to Tagereau, some men committed themselves out of shame, others lost their minds, and all were left destitute and sad. Men who were declared to be impotent further had to pay for the court proceedings and repay their wives' dowries if the annulment was approved. The court's procedures were fundamentally incorrect. The Marquis de Langley case is regarded as the final straw for the trial by Congress in France. After failing the trial in 1659, the Marquis de Langley had been judged to be impotent. He requested a second trial, but it was turned down. He was forbidden from getting married again, but he disregarded the decree and did so anyhow. He has 7 kids during his second marriage. The process ineptitude could no longer be disregarded. Women's possible benefits in impotence trials also attracted a lot of attention in the 18th century. In England, Catherine Aston said that the Earl of Wessex, Edward Weld, was impotent. Despite the fact that doctors and Edward both admitted that this was the case, Catherine's action was unsuccessful when her motivations were called into doubt. Despite never having been checked, she was instructed to go back home and bed and board her husband. The two were never parents, but following Catherine's passing, Weld remarried and had 5 children with his new spouse. The tabloids of the day published accounts of impotence trials. Popular real crime books were soon followed by in-depth reports of impotence trials. People consumed criminal tales, such as those about and adultery. Publishers like John Dunton and Edmund Curll pounced on interest in the most scandalous instances around the turn of the 18th century. Early in the 18th century, when Curll published 2 volumes on the Jesfra's impotence case, he introduced readers to a new degree of intimate intrigue and created an altogether new literary genre. Under the cover of legal and medical paperwork, obscene and contents made their way to interested audiences. In actuality, editors frequently called attention to the most scandalous aspects.